Every now and again I get an email to tell me that something in one of my videos is wrong. I say every now and again, practically daily, because my channel gets something in the region of 3 to 5 million views a month, so whittle those numbers down, and practically daily I get an email to tell me that something's not quite right. Now, this is not to say that everything I ever say is 100% correct. That would be inhuman and practically impossible. But rest assured that I do research my videos and they are usually correct, and if not, I'm happy to be corrected and I will own up to that and put a correction out. But on this occasion, it's not the case. This email says, please correct your factually incorrect video. This was regards to schools' policies on confiscating property and the specific defence available to them if they've disposed of such property. Now, this I thought was a great example from, let's call him or her G for the purposes of this video so as to anonymise them. G sent a link to a guidance document, which, as they say correctly, specifically relates to the area of schools looking through phones for material and deciding whether or not to destroy said material. And in particular, with respect to mobile phones. Now, it wasn't just the fact that G said my video was wrong, but the way in which they did so, which I thought was rather rude. I'm going to leave out most of it, but one bit of it said, as they often do, very shocked that you've repeated schools' lies and propaganda rather than actually check the legislation. I expected better from you. Now, this seems to be a go-to phrase, probably because of the name of the channel, and I get phrases such as, can't believe this is coming from a barrister, I thought you were a barrister, I would expect a barrister to know better, and so on. So I thought I'd do this follow-up video just to illustrate how referring to a guidance document and mistaking that with respect for the law leads to a misunderstanding. And I thought I'd take the opportunity to more fully explain this bit of the law that does indeed allow schools to do this in different situations. For example, the school can confiscate property by way of a disciplinary action, and they can confiscate property by way of a search for prohibited items. Now, for the avoidance of doubt, a prohibited item can include an electronic device if so device is being used or there's a suspicion that it's being used in the commission of an offence. I'll come back to that in a moment. Now, the important bit, or the interesting bit here, is that the guidance document that G referred to itself set out the bit of law that I was referring to with regard to confiscating and disposing of a pupil's property. In this case, in the guidance at paragraph 80, said schools' general power to discipline enables a member of staff to confiscate, retain or dispose of a pupil's property as a disciplinary penalty where reasonable to do so. And at paragraph 81, again referring to the law, says the law protects members of staff from liability in any proceedings brought against them for any loss of or damage to any item they've confiscated, provided they've acted lawfully. Now, this obviously requires them to act lawfully when confiscating the property, but then provides them an express defence if they were to dispose of that property in the process. Now, do I think it's likely that a school is going to confiscate an electronic device, more particularly a mobile phone, as a disciplinary action and then dispose of it? No, I don't. But there is a specific defence available for them to do so. But let's look at another scenario where said mobile phone is used in the commission of some kind of offence. Let's say that it is specifically used to organise the sale of drugs, or specifically organised to arrange a beating on another child, or even more nefarious and heinous crimes. Then the use of the mobile phone is something that is used in the commission of an offence. Now, diving back just for a moment, the bit of law for general confiscation where it's been lawful, the seizure, retention and disposal, The defence is set out in Section 94 of the Education and Inspections Act of 2006, which provides that a person who seizes, retains or disposes of an item is not liable in any proceedings in respect of the seizure, retention or disposal, as the case might be, or any damage or loss which arises in consequences of it, if he proves that the seizure, retention or disposal, as the case might be, was lawful, whether or not by virtue of Section 91, which is general discipline and so on. Now, that is the general express defence for the general seizure, retention and disposal of property which is against the school rules. However, in the case, as I'm now moving on to, where it might be in connection with the commission or suspected commission or in any respect related to an offence, subsection 3 of this section 94 provides that nothing in this section applies where an item is seized under section 550 ZC or 550 AA of the Education Act 1996. In reverse order, section 550 AA is in respect to weapons, but 550 ZC is a little bit more general. Now, this provides the power to seize items found during a search under section 550 ZA. Now, under subsection 1, a person carrying out a search under 550 ZA may seize any of the following found in the course of a search. First of all, in sub A, anything which the person has reasonable grounds for suspecting is a prohibited item, so drugs and things of that nature, or any other thing which that person has reasonable grounds for suspecting is evidence in relation to an offence. Now, interestingly, if we look further down in this section, we have to follow a bit of a breadcrumb trail to find the bit that leads us to the conclusion that schools can actually decide to dispose of a mobile phone. So bear with me, this does take a little bit to get your head around. First of all, we go down to subsection 6A within section 550 ZC, which was the power to seize items found during a search. Subsection 6A provides that a person who seizes an item that is a prohibited item by virtue of section 550 ZA sub 3 sub EA, which is an article used in the commission of an offence or to cause personal injury or damage to property. You see, even this section thought that it was necessary to explain what it meant. Because if we move over to section 550 ZA sub 3 sub EA, we find that it means that this is a prohibited item when it is any article that the member of staff reasonably suspects has been or is likely to be used in the commission of an offence, or, of course, to cause personal injury to or damage to property of any other person. So moving back to 6A, a person who seizes such a prohibited item, which could include a mobile phone, because it could be used in the commission of an offence, I'll come back to that in a moment, must then either A, deliver the item to the police as soon as possible, return the item to its owner, retain the item, so presumably indefinitely, or dispose of the item. So let's work through this for a moment. The school has the power to conduct a search. The school has the power to seize items found during a search. If they find a prohibited item, which includes any item that they reasonably suspect has been used to commit an offence, which could include a mobile phone, which I'll come back to in a moment, then they must either give it to the police, return it to the owner, retain it, or dispose of it. So they could dispose of it. So if a mobile phone applies in all those circumstances, they could dispose, or they must, as one of the options, choose whether or not to dispose of the item. And in doing so, they must have regard to several things, which indeed I will come back to in a moment. Now, coming back first of all to whether or not this could apply to a mobile phone. Now, as I said previously, do I think a school would generally confiscate and dispose of a mobile phone just simply as a penalty, a disciplinary penalty? No, I don't think they would. They arguably could, but I don't think they would. Could they, and perhaps would they, dispose of a phone that's been used in the commission of an offence, making it a prohibited item, thus giving the school, under the Education Act 1996, the option to give it to the police, the owner retain it, or dispose of it? Yes, they quite well could. Why would that be possible? Well, if you think about the use of a mobile phone in the commission of an offence, there are a number of different examples. Perhaps the phone has been used to arrange the supply of drugs. Perhaps it's been used to arrange the beating of another child. Perhaps it's been used for all kinds of other sorts of assaults that you could imagine that a phone could be used to organise. Now, this could be a number of different things, a number of different offences. If this particular school has a whole array of these offences going on and the school absolutely needs to stamp down on it and get rid of this particular type of offence within the school, and it's all being organised on electronic devices, phones, using encrypted messages. Let's say the school conducts a search, they find said device, they find out that it is reasonably suspected of being used in the commission of these offences, then under the Education Act, the school needs to make a choice as to what to do with the device. Now, there is statutory guidance, as the original email suggested, for dealing with electronic devices. Now, under this guidance, where a person is conducting the search finds an electronic device, they may examine any data files on the device that they think is a good reason to do so, and following the examination, if they've decided to return the device to the owner or to retain or dispose of it, they may erase any data or files if they think there's a good reason to do so. And the member of staff is advised to have regard to the guidance for schools when determining what a good reason is for erasing the contents of an electronic device, and in determining a good reason to examine or erase the data or files, the staff member must reasonably suspect that the data or file on the device in question has been or could be used to cause harm. And of course, this statutory guidance from the Department for Innovation and Business Skills, which is obviously aimed at schools, refers back to Section 550 ZC 6G of the Education Act 1996. And that is where it gets really interesting, because it specifically refers to electronic devices. Reading from Section 6D, it says that subsections 6E and F apply to an item that's been seized under subsection 1. So it's been seized with a search for a prohibited item by virtue of one of these sections, which is provided in B. So a prohibited item by virtue of section 550 ZA3EA or G, which includes obviously any item which has been suspected of being used in the commission of an offence, and is an electronic device. And so if all of those apply, so it's been seized, suspected of being used in an offence, therefore is prohibited, and it's an electronic device, then the sections 6E and 6F apply to that item. 6E provides that the person who sees the item may examine the data or files on the device if they think there's a good reason to do so. And 6F provides that following an examination under 6E, if the person's decided to return the item to its owner, retain it, or dispose of it, the person may erase any data or files from the device if they think there's a good reason to do so. So this expressly, in black and white, plain language, provides that the school may conduct the search, they may seize the item, they may search the files on the item, they may decide to return it to the owner, retain it, or dispose of it, or of course provide it to the police, as per subsection 6A. So this just goes to show that reading one guidance document, which in and of itself, by the way, did outline what I said in my original video, but misunderstanding bits of that in respect of the rest of the law, which as you can see is not entirely straightforward. This is not really meant to be a consumer-facing document. It is meant to govern the way schools operate. It's meant to provide schools with this authority and indeed statutory duty, where it says that they must do something. It's a duty upon them to do it. So if they have found an item in subsection 6A, if they seize an item that is prohibited, which is used in the commission of an offence, they must deliver to the police, return it to the owner, retain it, or dispose of it. And obviously if it's an electronic device, they can examine the files on it. And if they do so, they can decide to erase those files. Obviously, all of which, if there is a good reason to do so, and it is justified. So in the general sense, as a disciplinary action, the school can confiscate items, but in connection with an offence, the powers are far more broad. In fact, they are far more strict. They place a duty upon the school to do one of those things with the item. So they must choose to do one of those. They cannot just let it lie. So in conclusion, whilst I get many of these emails telling me that my videos are wrong and I don't always respond to them, this does provide a good opportunity to talk you through the process of understanding the law, which I don't always do in this much detail, but this is the extent that I go to read the law and all of the bits that it refers to link them all together, which ultimately provides the answers that I bring to you, usually in under 8 minutes. So hopefully that is interesting to you. Hopefully it reassures the few of you that possibly don't trust what I say. It's not to say that I'm going to be 100% accurate all the time, and I'm happy to be corrected if that's the case, and I will bring a correction to you. But in this case, that isn't so. So I hope you found that interesting. Please do bop that like button and subscribe. It does take a lot of time out of my Sundays and other days to bring these videos to you. I'll be very grateful if you do subscribe. And as always, thank you so much for watching.